La Cour.
Please be seated. I declare open the hearing for the delivery of the judgment of the Grand Chamber of the European Court of Human Rights in the case of Tsaava and others versus Georgia, pursuant to Article 44 of the Convention and Rule 77, Paragraph 2 of the Rules of Court. This hearing is being broadcast live on the Court's YouTube channel. The agents of the Georgian government and the representatives of the applicants have been duly informed about the date and time of this hearing. The Georgian government are represented by Mr. Bekad Samashvili, Deputy Minister of Justice, and I welcome the representative of the respondent state in the name of the Court. In my speech this morning, I will explain the procedural history of the case and give a brief outline of the facts. I will then read from the operative provision of the judgment, and following that, I will summarize the main findings made in this case. I should make clear that that explanation, the outline, and the summary that I will give are not part of the judgment and will not bind the Court. A more detailed account of the facts and a fuller summary of the Grand Chamber's reasoning can be found in the press release, which will be made available at the conclusion of this hearing. Moreover, the full text of the judgment will also be available on the Court's website. The procedural history of the case is as follows. It comprises 5 applications with a total of 26 applicants. The applications were lodged with the Court between February 2020 and August 2021. They were allocated to the 5th section of the Court. The Chamber of that section gave its judgment on the case on 7 May 2024. And at the request of the applicants, the panel of the Grand Chamber decided on 23 September 2024 to refer the case to the Grand Chamber. Leave to intervene at this stage of the proceedings was granted to 2 groups of non-governmental organizations, to 9 members of the International Network of Civil Liberties Organizations, and to PEN International, PEN Georgia, and English PEN. The interveners made written submissions on the case. The Grand Chamber held a public hearing on 26 February this year. It adopted its judgments on 8 October last. The case arose out of the dispersal by police of a demonstration in front of the Georgian parliament in Tbilisi on the night of 20 June 2019. The demonstration involved some 12,000 participants, and there were about 5,000 police on duty. There were some violent elements in the crowd, and, as the hours passed, some violent episodes at the entrance of the parliament as attempts were made to force through the police cordon and storm the building. The demonstration was eventually dispersed by the police using forceful means. In particular, a considerable number of kinetic impact projectiles, about 800 rounds, were fired. Some 200 people received injuries over the course of the demonstration and its dispersal. This included journalists, demonstrators, and also members of the police. 14 of the applicants were present at the scene as journalists. 11 were there to take part in the demonstration, and the remaining applicant was a bystander at the scene. All of them were physically injured to some degree during the dispersal. Most of them were hit by kinetic impact projectiles. For 4 of the applicants, this resulted in injuries to the eyes, causing permanent damage. Some of the applicants were subject to direct force by the police during the dispersal. A criminal investigation into the means used by the police began within 2 days of the incident. The applicants participated in these proceedings. Various steps and measures were taken in the course of the investigation, mostly in the first 1 to 2 years. At the time of the Grand Chamber's examination of the case, the investigation had not yet concluded, but was still formally ongoing. Apart from having been transferred from the Prosecutor's General Office to another authority, the Special Investigation Service, in mid-2024, there was little reported activity or progress with it in any recent time. The applicants complained that the forceful manner in dispersal of the demonstration was a violation of their rights. They relied principally on Article 3, Article 10 by the journalist, and Article 11 by the demonstrators. It is relevant to note here that when it examined the case in its 2024 judgment, the Chamber found a breach of the procedural limb of Article 3. It considered that the investigation had failed to meet the required standard of thoroughness and effectiveness in a number of respects, and that it had failed to conclude within a reasonable time. With respect to the other related complaints, the Chamber refrained from examining them. Instead, and with reference to the principles of subsidiarity and shared responsibility, it indicated to the Georgian authorities under Article 46 of the Convention that obligation to reactivate the investigation, to address the identified shortcomings with it, to bring it to a conclusion as soon as possible, and then to ensure accountability for any violations of the applicant's rights. The Chamber stated that if the Georgian authorities failed to comply with their obligations, it would be possible for the applicants to reapply to the court. I will now read the operative part of the Grand Chamber's judgment. For these reasons, the court, 1. Dismisses by 15 votes to 2 the first limb of the government's preliminary objection on non-exhaustion of domestic remedies. 2. Joins unanimously the second limb of the government's preliminary objection to the merits of the complaint under the procedural limb of Article 3 of the Convention. 3. Holds unanimously that there has been a violation of the procedural limb of Article 3 of the Convention with respect to all 24 applicants whose complaints under that provision were declared admissible, and dismisses the second limb of the government's preliminary objection. 4. Holds unanimously that there has been a violation of the substantive limb of Article 3 of the Convention with respect to all 24 applicants whose complaints under that provision were declared admissible. 5. Declares by a majority the complaints under Article 10 of the Convention in Tsaava and Gesmusov, Svanadze and Bagashvili and others admissible. 6. Holds unanimously that there has been a violation of Article 10 of the Convention with respect to the applicants in Tsaava and Gesmusov, Svanadze and Bagashvili and others. 7. Joins unanimously the government's objection that the complaints under Article 11 of the Convention are incompatible ratione materia to the merits of those complaints. 8. Declares by a majority the complaints under Article 11 of the Convention by 2 of the applicants in Kordovanidze and others, Mr. Kordovanidze and Mr. Sulashvili, admissible. 9. Declares by a majority the complaints under Article 11 of the Convention by the 9 remaining applicants in Kordovanidze and others, and by the applicant in Berikashvili, admissible. 10. Holds unanimously that there has been a violation of Article 11 of the Convention with respect to the applicants in Kordovanidze and others, and Berikashvili, and dismisses the government's objection that the complaints under that article are incompatible ratione materiale. 11. Holds by 16 votes to 1 that there is no need to examine the admissibility and merits of the complaints under Article 13 of the Convention. 12. Holds unanimously that the respondent state has not failed to comply with its duty under Article 38 of the Convention. I will not read out the operative provision number 13 and 14, which concern just satisfaction. Suffice to say that the Court has made awards in respect of pecuniary damage to 4 applicants, non-pecuniary damage to all the applicants, and costs and expenses incurred in the proceedings. I will now give a brief summary of the Grand Chamber's main findings. In the judgment, and in view of the manner in which the Chamber decided the case, the first matter examined is whether and in what circumstances it is open to the Court to refrain from examining part of a case. It reviews the principles governing the right of individual application under Article 34 of the Convention and affirms the corresponding duty of the Court to examine an application and to come to a final decision in relation to it. It states, and I quote, "Unless it applies a Convention provision which enables it to dispose of an application in some other way, the Court cannot refrain from deciding on its admissibility and, to the extent that one or more complaints are admissible, on the merits. The principle of subsidiarity and shared responsibility can have an impact on the Court's duty in this respect, but cannot, on their own, override it." Finding no justification to dispose of this case in any other way, the Grand Chamber considered that it must examine the complaints that the Chamber refrained from, that is to say, the complaint under the substantive aspect of Article 3 and the complaints under Article 10 and 11. Turning then to the findings under Article 3. Regarding the procedural aspects of Article 3, that is to say, the duty on the state authorities to conduct a thorough, timely and effective investigation into the manner in which the demonstration was dispersed, so as to determine whether the means used were contrary to the prohibition of inhuman and degrading treatment, the Grand Chamber agreed on all points with the Chamber's critical assessment. The judgment states, and I quote, "Although the investigation has been ongoing for more than 5.5 years, it has so far neither resulted in a comprehensive assessment of all the relevant circumstances, nor led to findings about the circumstances pertaining to the applicant's alleged ill treatment, or the identities of the state agents who used or ordered the use of allegedly excessive force against them, nor has it resulted in any relevant charges. It cannot therefore be regarded as effective." Unquote. Regarding the substantive aspects of Article 3, the applicant's complaint was that, whether struck by kinetic impact projectiles or subject to direct physical force from police, such treatment was unjustified. The judgment states, and I quote again, "It is true that the initial peaceful demonstration escalated into a violent confrontation between one part of the demonstrators and the police. It can also be accepted that in view of the scale of the disorder and the violent conduct of some of the demonstrators, individual officers might have been justified in the heat of the moment in firing kinetic impact projectiles to contain violent demonstrators and avert an honestly perceived danger to their own lives or those of others. There is, however, simply no evidence or even assertions on the part of the government with detailed reference to the individual circumstances of each of those 20 applicants that their injuries were the inevitable consequence of their own conduct or the use of such projectiles to contain violent demonstrators." Unquote. Concerning the 4 applicants who complained of the use of direct physical force against them, the Grand Chamber's conclusion is the same. The judgment further clarifies the necessary elements of the domestic legal framework regulating the use of kinetic impact projectiles. Having regard to the technical characteristics of kinetic impact projectiles and their potential effect on human health, the judgment affirms that, and I quote, "States must have in place and precautions ensuring that if kinetic impact State must have in place rules and precautions ensuring that if kinetic impact projectiles are deployed by the police during a demonstration, their use is appropriately circumscribed." Unquote. Drawing on relevant convention case law, and also on current relevant international standards in this respect, the judgment sets out what is required in domestic law, and I quote again from the judgment. A, that kinetic impact projectiles be used only as a last resort in response to genuine and imminent threats to life or limb. B, that they be deployed only in a targeted manner rather than as a means of general crowd control, and in such a way having due regard to the technical characteristics of the model used as to minimize the risk to the targeted person's life and health. C, that multiple projectiles on account of their inherent imprecision and projectiles containing metal on account of their increased capacity to cause serious injury not be used. D, that their use must follow an appropriate warning unless such warning is clearly unfeasible. E, that kinetic impact projectiles be deployed only by law enforcement officers who have been properly instructed and trained, not only about the projectile's technical characteristics, but also about the risk that they may pose to life and health. And F, that the deployment of kinetic impact projectiles be subjected, insofar as possible, to a strict chain of command and control, unquote. In light of these circumstances, the Grand Chamber identified a number of shortcomings in the domestic framework, which appeared to have had a bearing on the manner in which the demonstration was dispersed. For this reason, too, it found a substantive violation of Article 3. I then turned to the findings under Article 10. 14 of the applicants complained that the treatment they have been subjected to, as they reported on the demonstration and its dispersal, violated their freedom of expression as journalists. The judgment finds that the interference with the applicants' rights, i.e., the use of forceful means to disperse the demonstration that caused them physical harm, did not meet the requirement set under the second paragraph of Article 10 of being necessary in a democratic society. It states that it could not be accepted that the use of force found to be in breach of Article 3 could come within any acceptable margin of appreciation of the Georgian authorities under Article 10. The duty of states to have in place an effective system for the protection of journalists, established in the Court's case law and reflected in the standards adopted by the Council of Europe, is emphasized in the judgment. Turning then to the findings under Article 11, 11 of the applicants complained of a violation of their right to freedom of peaceful assembly. This raised the question of the peaceful intentions and behavior, or otherwise, of these applicants, a matter in dispute between the parties. The Grand Chamber found no indication that the demonstration at the outset had been intended to be anything other than peaceful, or that the participants, the applicants in particular, had had violent intentions when joining it or had been prepared for violence. The judgment also states, and I quote, "The seriousness of the situation and the need to ensure the effective functioning of Parliament, which is a key value in a democratic society, must be taken into account. It can also be accepted that the authorities were faced with a difficult task in preserving public order once some of the demonstrators had attempted to storm the Parliament building. However, even assuming that the statement made by some politicians present at the scene may have negatively affected the subsequent developments, this element, whether taken alone or together with the relatively limited group of protesters trying to storm the Parliament building, cannot deprive several thousand peaceful protesters of their rights under Article 11, unquote. In examining the justification for the interference with the applicant's rights under Article 11, the judgment then states, and I quote again, "The Court must be particularly mindful of the fact that the demonstration took place around the Georgian Parliament building and involved attempts by some of the demonstrators to storm the premises. It emphasized in this connection the fundamental interest of ensuring the effective functioning of Parliament in a democracy. The Convention establishes a close nexus between an effective political democracy and the effective operation of Parliament, and there can be no doubt that the latter is a value of key importance for a democratic society." Unquote. The Grand Chamber recognized that in a situation of tension with persistent and violent conduct in the front rows of the crowd, it was arguably justified to disperse the demonstration, especially since it was taking place just outside the Parliament building. But the manner in which the dispersal was done could not be justified. In particular, because no order to disperse was given to those present, and nor a clear audible warning about the impending use of kinetic impact projectiles. And above all, because of an unjustified degree of force that was used against the applicants, causing all of them physical injury. These can be considered to be the main findings of the Grand Chamber in this case. As is clear from the operative provisions, the case also involved complaints under Article 13 and Article 38 of the Convention, and the Grand Chamber has indicated both individual and general measures to the Georgian authorities under Article 46 of the Convention. On these points, and on the points that I have touched upon, I refer you to the judgment itself. With this, the proceedings of this morning come to a conclusion, and I accordingly declare this hearing as closed.